Hi, I'm Jim Brazil in Roseville, California.
And I'm Jim Brazil in Chico, California. And what we're going to cover this time is, after about 40 years of talking to people about how to put their living trust together and working with attorneys, some recent laws have put a real problem with most people's living trust. And these recent laws may make it to where your current plan is not only outdated, but could cause some real problems for your spouse and your heirs.
In traditional estate planning, typically those of you who have a living trust would recall that they would describe it or illustrate it as an A-B trust. So at the first estate of a married couple, when one passed away, the assets would be split between the survivor's assets, the A trust, and the deceased spouse's assets, the B trust. And almost everyone needed a living trust because of the estate tax laws having a very low exemption of what could pass estate tax free. For many years, from the late 80s all the way through the early 2000s, it was only $600,000 per a married couple or per individual. And so for most people, especially in states like California and others, just having a house and a minimal amount of assets would require setting up an AV trust to avoid estate taxation.
So since we were, in a sense, trying to get both exemptions for both spouses, it was necessary to have some type of trust that at the first estate set aside at least half of the estate that wouldn't be taxed at the second estate. And this has basically worked for 40-some years. But now there's a change, and that particular change is going to make the planning change. But let's talk about the other side of that bypass trust, Jim. The tax side once the survivor had two trusts.
Yes, so with the bypass trust, what would happen is at the second, after the first estate it was formed and the assets were split between the A trust assets and the B trust assets, and since there was a married couple, all the assets would receive a step up in basis. Many of you probably have heard that term over the years, but essentially any capital gains are forgiven at the first estate because all the assets get a current revaluation at that first estate. But the assets that were put in the bypass trust did not receive a step up in basis when the survivor passed away. So any gains in there when they were finally, the assets sold, would create capital gains tax. So it wasn't the most efficient from a capital gains tax standpoint, but the overriding reason for doing it, the high estate tax, made it a worthwhile trade-off. Today what's changed is the exemption amount that can be passed over. Instead of being a modest $600,000 or even $1 million, which it was fairly recently, it's now $5 million. So there may not be this reason to do the bypass trust and avoid the estate tax. However, there may be a shift in planning to eliminate the capital gains tax and possibly not even form a bypass trust.
The other thing that we ran into through the years is once we had the two trusts, there had to be two tax returns every year. And since surviving spouses sometimes could live many, many years after the first spouse passed away, they're paying for two tax returns instead of one. Also, the bypass trust a lot of times was written where the income that's earned in there would go to the survivor. So therefore there had to be an actual physical distribution of money out of the bypass trust into the survivor's trust. And a failure to do that could sometimes create problems at the second estate because it hasn't been moved. So those two problems, one, the lack of step up in basis and the fact that you had two tax returns, actually created a problem not only for surviving spouse, but also for the heirs. But it looks like, Jim, that's changed.
Yes, so what's important to look at today is essentially all estate plans that have been done under the presumption that there would be a low estate tax exemption, and most people who had accumulated some assets would need to pay estate tax. That's changed entirely to where almost all people, except for maybe the very highest 1% or less, won't have an estate tax and they should revisit their estate plan, their living trust. It potentially is written exactly the opposite of what it should be.
We have run into this problem a number of times already, where a first spouse dies and we could see easily that setting up the second trust was totally unnecessary. Yet we saw, because the document was written that way, attorneys and CPAs and ourselves had to explain to the client that you do have to do it. I think that almost all the plans that we've been part of planning for the last 40 years need to be looked at, because I'm not sure a lot of our clients need to have the bypass trust anymore, but they might need to have another trust anyway.
Yes, so you can form different types of trust to accomplish what you want, still receive a step up in basis, and still have the assets go the way you wish. The other completely new law, not just changing a dollar amount, but changing a provision, is a new concept called portability. And so you would not even lose your exemption amount if you didn't form a trust, but you could have it port or continue on to the surviving spouse. That's probably a topic to look at for another day.
So what we've got here with our clients is we need to review your living trust. We need to explain to you in more detail why using this portability and maybe not the bypass trust is better. There'll be a couple of exceptions. One I can think of, second marriages where there are children from different spouses. I can also think of some business reasons. But the bottom line is almost all living trusts are now going to cause problems that the preparer never looked at before.
Yeah, so going forward, really essentially everyone needs their living trust reviewed. And this is an area that we think that you all should take a look at and be certain that your plan is set up correctly for today's laws and not yesterday's.